Greetings from the Texas Education Agency. In this presentation, I will go over the new requirements from House Bill, or HB, 3928, which was signed into law on June 10, 2023. During this presentation, I will be covering all of the updates to the Texas Education Code sections listed on this slide pertaining to House Bill 3928. Note that this overview is not intended to provide agency guidance on how to implement this bill, as that will be communicated at a later date. The bill modifies Texas Education Code, or TEC, Section 7.102, C28, and states that the State Board of Education program currently defined in the Dyslexia Handbook 2021 update may not include a distinction between standard protocol dyslexia instruction and all other forms of direct dyslexia instruction, including specially designed instruction. This means that Admission, Review, and Dismissal, or ARD committees, will continue to determine what type of instruction a student needs without distinguishing between standard protocol dyslexia instruction and specially designed instruction. While the State Board of Education has until June 30th, 2024 to make these changes to the handbook, local educational agencies, or LEAs, need to begin to operate as if there is no longer this distinction. TEC Section 29.0031A, Dyslexia and Related Disorders, is added to Subchapter A, Chapter 29, and states in part that dyslexia is an example of and meets the definition of a specific learning disability under the Individuals with Disabilities Education Act, or IDEA. As a reminder, the current Dyslexia Handbook states that identification of dyslexia meets the first prong of eligibility for purposes of the IDEA as a student with a specific learning disability in basic reading or reading fluency. The addition of this language in the Education Code ensures that dyslexia does not otherwise have to be described formally as a learning disability in basic reading or reading fluency, and therefore meets the definition of specific learning disability. TEC Section 29.0031A also states, if the district suspects or has reason to suspect a student has dyslexia and may be a student with a disability under IDEA, the LEA must provide parents or guardians with a form developed by the Texas Education Agency explaining their rights under IDEA that may be additional to rights under Section 504. Comply with all federal and state requirements, including the Dyslexia Handbook, regarding any evaluation of the student. And if the student is to be evaluated for dyslexia or a related disorder, evaluate the student in all other areas of suspected disability. TEA is in the process of developing the required form for LEAs to use. Note that the same process would apply if the parent brings forward a request for an evaluation based on a suspicion of dyslexia. TEC Section 29.0031B states, the Multidisciplinary Evaluation Team and ARD Committee must include at least one member with specific knowledge of the reading process, dyslexia and related disorders, and dyslexia instruction. The member must hold a licensed dyslexia therapist license under Chapter 403 of the Occupations Code, hold the most advanced dyslexia-related certification issued by an association recognized by the State Board of Education, or if neither of these is available, the member must meet the training requirements adopted by the State Board of Education. This is another requirement of the State Board of Education. Next, we'll learn about required documentation regarding this member's participation on the Multidisciplinary Evaluation Team and ARD Committee. TEC Section 29.0031C requires that a member with knowledge of dyslexia and related disorders on the Multidisciplinary Evaluation Team and ARD Committee must sign a document describing the member's participation in the student's evaluation and any resulting Individualized Education Program, or IEP, developed for the student. A signature of participation would be true for any member of the evaluation team or ARD committee. TEC Section 29.0031D, at least once per grading period, or more often if required in a student's IEP, the LEA must provide the parent or guardian of a student receiving dyslexia instruction information regarding their child's progress as a result of receiving that instruction. This would apply regardless of whether the student receives dyslexia instruction under Section 504 or through an IEP. TEC Section 29.0032, Providers of Dyslexia Instruction, is added and provides guidance on training requirements for dyslexia interventionists. Dyslexia providers must be fully trained in the LEA's adopted instructional materials for students with dyslexia. Dyslexia providers are not required to hold a certificate or permit in special education unless they are employed in a special education position that requires the certification. The completion of a Literacy Achievement Academy does not satisfy these training requirements. Subsection P is added to TEC Section 37.006 and now requires, upon placement of a student in a Disciplinary Alternative Education Program, or DAEP, a parent or guardian must be provided with information on how to request a full individual and initial evaluation, or FIIE, under the IDEA. Students placed in a DAEP must be provided a personalized transition plan when returning to the student's home campus. Prior to the amendment of this law, the campus administrator could, but was not required to, provide, as part of the personalized transition plan, a notice to a parent of their right to request a special education evaluation. The change in law now makes this a requirement. TEC Section 38.003B was revised and states that each Board of Trustees of a school district or governing board of a charter school must adopt and implement a policy requiring the LEA to comply with all rules and standards adopted by the State Board of Education to implement the program, including the Dyslexia Handbook and Commissioner of Education guidance. Please note that compliance was required even without a board policy, but the new requirement is to ensure that this is a priority for boards to address. TEC Section 38.003C-1 is revised to require TEA to create procedures through the rulemaking process to allow TEA to seek out parental input on an LEA's implementation of the dyslexia program as part of the agency's dyslexia monitoring process. The State Board of Education must revise the Dyslexia Handbook by June 30th, 2024. The State Board of Education also has to address the training requirements for the Multidisciplinary Evaluation Team and ARD Committee member. The law applies beginning with the 2023-2024 school year. The piece that requires specific State Board of Education action will ultimately be required once the State Board of Education takes that action. But districts must still implement that section based on the law's intent to the maximum extent practicable. Thank you for participating in this recorded session about House Bill 3928. TEA will release additional guidance and technical assistance. For more information or questions, please contact the Division of Special Education at the email address on the screen.